Welcome back to our webinar on estate and business planning. In the last segment, we were talking about asset preservation and how the living trust can provide creditor protections on your assets when the first spouse dies. Or if we're talking about a single individual, when you die, your assets can be protected from the creditors of your surviving spouse and or your children. So here is an example of a joint married couple living trust. So this is a joint trust, and it provides that when the first spouse dies, a portion of the assets of the living trust are going to be pocketed in one or both of these boxes. If this estate is going to be subject to a death tax, we anticipate that this estate will be subject to a death tax, which federal law says that death tax is going to be imposed on the second to die. Then this is an opportunity for the surviving spouse to move a portion of the assets over to the green box, so that by the time that she dies, the estate has been reduced below a certain amount where it would not suffer any death tax. Okay? A lot of my clients are not using the family trust box anymore because because they just don't have an estate that's big enough. They're worried that they'll suffer a death tax. So a lot of my clients are still putting the marital trust box in, and so you see some trusts that just have the orange box and then the pink box. And when the first spouse dies, then if you have this pink box, the marital trust, already embedded into the original document, this is put into the document way back when the couple created this trust. When the first spouse dies, the surviving spouse is instructed to put the first spouse dies share of the assets into the pink box. And the assets of this marital trust, I call it the pink box, but it's the marital trust. The assets of the marital trust are protected from the surviving spouse's future creditors. What could be the future creditors of the surviving spouse? Well, remarriages. So if you're worried that your surviving spouse is going to get married again and that the new spouse will take everything, if you have the marital trust holding the first to die spouse share of the assets, then those assets are protected from remarriages. Okay. And also creditors of the surviving spouse. So if the surviving spouse suffers a bankruptcy or is being sued, those creditors can take the rest of her assets that are left up in the master trust, but they can't come and take the assets of the marital trust. In most cases, it depends upon the client, but the surviving spouse is the only trustee of the marital trust. So she has control. She has control of the assets of the marital trust. And in most cases, the surviving spouse is the primary beneficiary of the marital trust, and she can use these assets for her health, education, and support. So she has access and control. Another creditor would possibly be nursing homes. So a lot of folks are really worried about nursing homes, and medical costs have skyrocketed. So this would be another, these assets would be protected from the nursing home creditors of the surviving spouse. Now once the surviving spouse passes away, the master trust and the marital trust go away, are terminated, and those assets are then distributed to the children in creditor protection trust. And in a moment we're going to see what types of creditor protection trusts we can create for your children or beneficiaries. So we talked about the marital trust for the surviving spouse, and then once your spouse dies, those assets will be distributed to your children, and you may want to protect those assets from your children's creditors or from your child. And I always like to describe it this way. There are 4 ways, standard ways, that you can leave your inheritance to your child. Okay, the first way is outright. where there are no restrictions. Your child just, takes their check, their inheritance, and walks away, and it's theirs. It becomes part of their personal estate, and then subject to whatever may be going on in their lives at that time. We typically don't advise to do that these days because, your child could be going through a nasty divorce at the time of their inheritance, or they could be being sued by somebody. The second way is a trust at their convenience. So here is where your child receives their inheritance, but they receive it in a trust, and your child is the trustee, your child is the beneficiary. So while they have control over it and they can access it for what they need, for a standard of what their needs are, their creditors can't take it. So you kind of get the best of both worlds there. Your child can access it for whatever they need, whenever they want to. There's no limits on their control or access to it. But the big benefit is their creditors can't take it, because technically the trust is the owner. Your child is not the personal owner of those assets. Trust at their convenience. We usually recommend the trust convenience trust for adult children who are healthy and they don't have any real problems going on, no real creditor problems, and they're not spendthrifts. They're responsible. The third way that you can leave inheritance to your child is in a trust, but your child does not have control over it. So this would be what we call these general needs trust. So your child may be too young, maybe they're a minor. So here that you would provide that they would not have control over their inheritance until they reach a certain age where you felt they had the mental maturity to be able to control and manage their own inheritance. So we start off with a restricted trust where you have somebody else, a trustee, managing the money for your kid, and then when your child reaches that particular age, then your child takes over and is able to control it. And the fourth and final way, I like to call these, are lifetime trust. Your child is never the trustee, and so you're going to have someone that's managing that trust for the life of your child. These are, we put special needs trust in these categories, or just a typical lifetime trust for a child who's healthy but's a spendthrift, or a child that has a lot of creditors out there, and we wouldn't want your child to be the trustee, which would make it more vulnerable to being attacked by their creditors. So 4 different standard ways. We mentioned here a general needs trust for minor and young children. Okay, so we have a trustee managing those until your child reaches a certain age that you feel comfortable where they can manage their own inheritance. Spendthrift trust for those children who really can't save any money and are not responsible, likely give their inheritance away to strangers. Special needs trust for children who are receiving government money. Special needs kids are receiving some government aid and benefits. They're not allowed to have very many assets, and so if your special needs child did receive a large inheritance, then the government is going to take it and to repay them back for all the aid that they've given that child. Here is a photograph of my boss, Jim Seidel, and his son. So Jim Seidel has a special needs son, and so he's very, very familiar with the documents that need to be in place and the various different provisions for holding a special needs child's inheritance. He is standing in front of his yacht. No, just kidding. But so there is him and his son Jimmy. Okay, I'm going to talk a little bit about long-term care and catastrophic illnesses. So everybody's worried about the nursing home. The cost of nursing homes and medical costs have just skyrocketed, and it's a lot. And I've seen estates, I've seen $500,000 estates wiped out, vanished in a couple of years because of these costs. So it's something real and frightening that we're all worried about, especially if things like dementia or Alzheimer's runs in your family and you think that you're going to live for a long, long time, but your cognitive health is going to decline, where you're going to need to have long-term care, and you're going to have special medical care watching you around the clock, and that's when those costs really skyrocket. So there's only so much you can do with estate planning, but I do have some clients that come in that want to divest themselves of their assets and give their assets away to what we call an irrevocable trust. Okay, so that's different from what we've been talking about tonight or today. We've been talking about a living trust, which is holding your personal estate. But we can also provide a irrevocable trust. We can prepare an irrevocable trust, and then you can give all your assets away to that irrevocable trust, impoverishing yourself. You have to alert the government that you're making these gifts, because they're more than the $15,000 you're allowed to gift. So you have to file the 709 tax return in the year of the gift, alerting the government that you're making these gifts to this trust. Keeping in mind there is a 5-year look-back period on those transfers. So if you have creditors during that first 5 years, those creditors can get paid out of that irrevocable trust. After the 5 years has lapsed, then it becomes a completed gift and it's safe from your creditors. Here is an example where we have a life insurance trust. And a life insurance trust typically will be the owner of a life insurance policy and will be the beneficiary of the policy, so that it's a way to have your loved ones, your spouse, and your children still receive an inheritance, even though you're completely impoverished by the time you die. So there's nothing in your estate. Your estate may still have a lot of creditors, but there's nothing in the estate for the creditors to take. So we have this life insurance trust, which still provides money to your spouse and your beneficiaries, and that the assets of the life insurance trust can't be taken by the estate creditors. I always tell my clients that they should talk to their insurance agent about some insurance products to help thwart the cost of those expenses on their estate, like using long-term care insurance or disability insurance, life insurance, annuities. Again, the life insurance, in order for it to be completely protected from the creditors, should be in its own separate entity, such as an irrevocable life insurance trust. A few long-term care statistics. Now, these are a little outdated, so I apologize, but about 70% of Americans who live to age 65 will need long-term care at some point in their lives, and 40% will be in a nursing home. That's a terrible, scary statistic. If you're 70% of all Americans over 65 are going to have to, or 70% of all Americans who live to age 65, 40% may be in a nursing home. As of 2008, the national average cost of a private room in a nursing home was $212 per day, or $77,000 per year. That was in 2008, so we know that was about 12 years ago. So it's a lot more expensive now. On average, someone age 65 will need nursing home care for approximately 3 years. So that's why those long-term care policies you get, they're usually like 3 to 5 years, because those experts know how long you're going to be living once you get in a nursing home. 20% will need nursing home care for about 5 years. Okay, so you can get those long-term care policies that can cover 3 to 5 years. And then you need to make sure you talk to your agent, because those can cover different ranges of things depending on how much money you want to pay for the policy. 50% of all couples and 70% of all single persons will become impoverished within 1 year after entering a nursing home. Yeah. So once you get into a nursing home, especially if you need round-the-clock care because you have a cognitive illness, that your estate's going to be wiped out very quickly. Long-term care is not just for the elderly. A study by a large insurance company found 40% of all long-term care claimants were under the age of 65 at the time of disability. So it's stuff that we really need to consider, and we've got to worry about that. So, but there are there's some estate plan documents that we can do to help protect these costs on against your from your spouse and your children from having to suffer those costs. Business and estate planning. So we have a lot of clients who are running businesses, and so as such, we need to make sure that we incorporate their businesses in their estate planning. If you are running a business, then you have a higher likelihood of being sued because you are regularly interacting with the public. Okay, so and you're going to be sued by your customer. You might have a disgruntled customer. They might have think that you wronged them in some way. Or if you are running a business and renting a beach house to college students, then you run the risk of them injuring themselves. And they're going to come and they're going to want to sue you for their injuries or their harm done. So if you're running a legitimate business, if you incorporate your business with the government, the state government, then the government says that you're going to get personal liability protection. The creditors of your business will only be able to sue the business itself and take assets of the business and not come after your personal estate. So we do have a lot of clients who are running businesses, and we highly encourage them to incorporate those businesses with the state to protect their estate, their personal estate, against creditors. This is a diagram of a living trust package. This particular couple, we know that it's a joint living trust because we see the blue and the pink box below to hold a share of the first to die spouse's assets to save against death, taxes, and creditors of the surviving spouse. We see businesses, so this couple had businesses. Those businesses have been incorporated to provide creditor protections on the personal assets, and those businesses have been assigned to the trust. If you have a business, you want to assign it to the trust so that if you become disabled or if you die, this is going to allow your trustee to be able to continue the management of the business if you're disabled and settle the business when you pass, hopefully without having to go through any probate process. We see here that upon the second spouse's death, we have their 3 children here receiving their inheritance in these various creditor protection trusts. So our process, we offer a 2-hour introductory estate plan consultation, and there's no charge for this initial meeting. So you're getting a lot of really good, valuable information specific to your needs, specific to what your plan is going to look like in this initial consult. Earlier at the beginning of this workshop, I told you that there was the yellow canary form. If you want to have a meeting with one of our staff, all you have to do is fill out the form and send it to our law firm, and someone from our law firm will schedule an appointment with you. And of course, the first meeting, there's no fee or obligation for that. The planning process. Okay, so this is an interesting study that was done by a major university. Northwestern University had provided a study that 5 to 6 hours of estate planning can literally save you hundreds of thousands of dollars over your lifetime in estate settlement costs, not just settlement costs, but pre-death costs such as guardianships, conservatorships. So just a few hours of time and a few documents in place, you're going to save your family and your assets a lot of money. So estate planning is going to provide time savings. So if you have the documents in place that allow your family to handle these things for you when you become disabled, when you die, there's no need for the government to come in, and the government has that lengthy, burdensome probate process before death and after death. It reduces the emotional costs, avoids family conflicts, and it leaving a legacy of love. So I always like to tell my clients that if you have a plan in place, and everybody knows what the plan is, And if you're comfortable, you should meet with your kids once a year and tell them what the plan is, so nobody's left out in the dark and there's no bitter feelings left. Because the last thing you want is, when you die, to have your children never speak to one another. I mean, that would be horrible. So having a plan in place is going to just keep the peace within the family. So our process, we call these planning meetings. So the initial meeting, that's a 2-hour free, no obligation meeting. That's where you'll meet with a member of our staff, and we will advise you on a plan that we think is appropriate for you and your family and your assets. If you decide to go forward, and we also quote you a flat fee. We do flat fees. We don't hourly rate, so you know exactly what the fee is going to be from the beginning. Then if you decide to proceed, we schedule the planning meeting. So at the planning meeting, that's when I call that decision day. You need to have all your decisions ready by a planning meeting. And the planning meeting is a 2-hour long meeting. So sometimes I'll tell my clients that even if you're still confused or foggy on what your decisions are, you still want to come to the planning meeting, because usually our staff is going to be able to help you make your conclusions and decisions at the planning meeting. And then the signing meeting is when we will bring your documents to you, and we have various satellite offices available to meet with you throughout Virginia and even in Maryland. So we'll personally meet with you, give you your documents, go over everything with you, have you sign everything, and then if you're doing a living trust, we will at that time give you what I call the homework for you to put your assets into the trust. And then if you are using a living trust, we typically give you about 60 to 90 days to get that homework done, and then we'll call you on the telephone and go over all of that and make sure all of that was done properly. Okay, so we talked about this. The initial meeting is a couple hours long, and we review the specifics of your situation. Okay, so we really hone in on what your issues are, and then we talk about a plan that's customized to you. Planning meeting is when you come back to the table and you make your decisions. See, at that initial meeting, you're given a lot of information, and you're going to have to make decisions. So we want you to have some time to think about what your decisions are going to be before the planning meeting. So the planning meeting is a second meeting where you come to the table prepared with your decisions. Okay, so the initial meeting, we talk about all of these things. Now the signing meeting is when you execute your documents, and then you begin the funding process if you're using a trust. And then we call you probably 60 to 90 days. We give you 60 to 90 days to put your assets into the trust. We want to make sure that you get verifications that all those assets have been transferred to your trust before we have the funding meeting. And there's a place in the binder which I think you should list all the assets of the trust for your loved ones and your trustee. We do recommend that you have your plan reviewed every 3 years, because memories tend to fade, and at the 3-year meeting, what we will do for you and with you is go over your estate plan with you and refresh your memory to how your plan works, and to the people that you've named in these various roles, and how your children inherit. A lot of times, my clients will actually bring their children to the review meeting so the children can hear firsthand from the lawyer what the plan is. So those 3-year review meetings are very good to have, and especially if you might want to make some changes too. And so we'll talk about updating your documents at that time. There is the secretary, receptionist of our law firm. Probably one of the most important persons in our law firm, Linda Palmer. She sits at the helm and she answers all the phone calls. Very, very lovely woman with a beautiful southern accent. So you're just going to love her to death. So she will call you. So if you turn in the Canary form, she's going to be the one that's going to call you and schedule your meetings. So you can look for a call from Linda. So I want to thank you for watching and listening this webinar today. You can find more information about the documents, or there's going to be some documents that are on our website that you can certainly pull down and look at later. And then we will post additional information on our website for upcoming seminars. And thank you so much.